is in a somewhat similar situation, but everybody's circumstances differ greatly. So everybody kind of has their own concerns and their own events that are going on in their life. So if you do have any questions that you kind of want to hone in on with respect to yourself, then just feel free to interrupt and ask, and we can talk about that, because there's a lot that goes on with divorce law and a lot to it, and a lot more than what we can discuss today. So, in my practice, there's a couple kind of basic things that people don't seem to be aware of with respect to divorce. I'll kind of start there. So, divorce technically is a lawsuit. It involves the filing of a complaint in the circuit court against your spouse, and then the spouse becomes the defendant. So there's a plaintiff and there's a defendant, and there's documents to initiate the lawsuit. And what I'll be talking about today is absolute divorce. So you might see information about limited divorce. That's more like what people call legal separation. There's usefulness for that, but absolute divorce is where you want to become divorced and separate and move on with your life. Divorce is different if you have minor children, if you have custody or child support needs. You might have alimony needs as well. So, like I said, everybody's situation is different. But one of the things that people don't understand is that it's a lawsuit. And I will say that if you decide to get an attorney at the beginning of your case. And the reason is because it is a legal process, because it's in the circuit court. The circuit court has court rules and procedures, and they apply to you. And it helps to have someone navigate the system for you. And the other advantage, I think, of having an attorney is that usually at the time of divorce is very emotionally exhausting and tumultuous. Divorce law and divorce cases are very active. Something might happen one day. Somebody shows up at the house, or somebody took something. Who knows? I mean, there's always something going on usually. And an attorney can be an objective eye on the case to help give you advice and give you counsel, because they're not emotionally involved in the case and can look at things from a legal perspective to help you make wise decisions. Because everything that you do and everything that, to be honest, both of the spouses have done in the past will come to light. And it can be used against you. So if you do get an attorney, it's best to get an attorney up front to kind of help get things on the right foot. The other advantage is you might be able to settle your case early and get the divorce done much more quickly. Okay. So with that said, I'll just kind of get into what are called the grounds for divorce. So people ask, do we need to live apart, and when can I file for divorce? So there's different grounds for divorce, different reasons that you can file for and obtain a divorce. The General Assembly several years ago added what's called mutual consent to divorce, which was desperately needed and wanted for a long time. And that is where the spouses, ahead of time, before even filing the lawsuit, filing for divorce, they come up with a marital settlement agreement that addresses everything that the court wants addressed. And in a divorce case, what the court is really looking at is what's known as marital property, which I'll talk about. If you have children, then there's child custody and child support issues, and things like that. So the marital settlement agreement is a detailed contract, essentially, where the parties work things out ahead of time. So if you're at a point where you can at least talk to each other reasonably, or things have cooled down a little bit and you can have rational discussions about that, that's often a good way to go, is to get an attorney. And each of you should have your own attorney, but you can also share an attorney for a marital settlement agreement purposes only. If you want someone to draft an agreement, and then once the agreement's signed, if it addresses everything, then you file for divorce and attach the agreement and tell the court, hey, listen, we've come to a resolution on everything, and we just want the divorce. It's uncontested at that point. There's nothing that we disagree about. Might not be happy about everything, but we don't have any legal disagreements anymore, and that's mutual consent. And that's really the fastest way to get through the court system, fastest way to get a divorce, an absolute divorce, and the fastest way to move on with your life. It also gives you more control over your case than what you would otherwise have. The justice system, judges in particular, can be very capricious in a sense of meaning you don't know what the outcome's going to be. You don't know what judge is going to get assigned to your case or how they've ruled in the past. And the litigation process itself, if you have to take things all the way to a trial, it is exhausting. Litigation is very involved, very tedious. It will take some toll on you energy wise and mental health wise for sure. um, all the stuff of each spouse comes to light. So there's embarrassing things and there's negative things, and then you have to counterattack back, and it becomes really litigious. And then you end up with a trial, and you don't know how it's going to turn out. So the doing things up front, trying to work out an agreement is usually the best way and the easiest way. Okay, and that's called mutual consent grounds. The other grounds that often, the other more frequent ones are the 12-month separation. And so that's where you must live separate and apart without cohabitation. So that means that one of the spouses literally needs to move out into a different residence, and you cannot spend any nights together. You can't be intimate together. You can't go on dates. You can't hold yourself out as husband and wife. You need to move out and stay that way for a continuous period of 12 months. And then you can file for divorce on the grounds of the 12-month separation. You can, so again, it's a little bit different than mutual consent, but you can still work on an agreement, a settlement agreement, if you've moved out. Okay, so just understand that along the process of any of these grounds, it's still possible to work out a settlement agreement as long as both of you are willing to do that. But that's you often see where the 12-month separation is ruined because there's one or two times where people get together and they kind of make up for a day or two, and they stay the night, and then that gets ruined. That will literally ruin your grounds for divorce on the basis of the 12-month separation because there's been cohabitation or intimacy.
I'm sorry, can I ask a question?
Sure.
Is there something to lose if a person, let's say it's a contentious divorce to begin with, is there something to lose if you move out? Like, could that be seen, especially in custody cases? Could that be held against you in some way if you're the spouse that leaves the marital home?
I mean, I hate to say it, it depends. One of the keys to divorce, and what I tell my clients is this, be reasonable in what you do and why you do it. And that's much easier said than done under the circumstances. But regardless of how your spouse is acting, again, everything comes to light. The text messages, the phone calls, or the voicemails, or video recordings, or who knows, it's all going to come out. And so it's best if you are the one who's reasonable in your actions and being justified in doing what you're doing. And so that's where an attorney can help you. So like moving out, I mean, for example, here's a bad example. My client was the wife with a 6-year-old child. The husband moved out. So what happened was they came home, the mother and the 6-year-old came home to no lights and no heat, middle of winter. with a note on the television saying, "I didn't pay the rent for the last 6 months, ha ha ha." And by the way, there's an eviction notice on the kitchen table.
So that's considered not rational.
Yeah, that's a bad moving out, right?
Bad,
Yeah, and judges see a lot of stuff, but that's the point where you don't want to move out. It would be bad to move out under the circumstances and doing that. If it's something where like you have abuse going on, or mistreatment of children or both, then moving out to protect the children or to protect yourself and the safety, then that's justified. I mean, that would be reasonable under the circumstances. Okay. But one of the things you do have to keep in mind is that judges, they usually don't like it when one parent might like kidnap the kids, take the kids in the middle of the night and move out, and then not say where they are and not expose them to the other parent who may not be dangerous. And so you want to be careful of that, where judges they like both parents to be involved as long as it's safe to do so. Okay. So you don't want to
kidnapping is also a bad thing.
What's that?
Kidnapping is also bad.
Yeah, I mean, taking the kids and running off, and I'm not telling you where they're at. I'm not telling you where we are, and you're not seeing the kids. That will be counted against you. I mean, that's just negative, because it's not. Courts view it generally as it is healthy and good for children to be exposed to both parents. Again, as long as it's safe to do so. So I see some questions popping up, but okay.
So generally,
The mutual consent, and then confused about how those are different, the 12-month separation. Well, the mutual consent requires an agreement to be signed. And sometimes you have a spouse who just won't participate and won't sign an agreement. And so you have no other choice than to move out and let the period run and then file. So that's the difference.
The 12-month thing is, if you're working together with each other and you say I want a divorce, and the other person says I want a divorce, so good, you go for mutual consent. But if the other person is not
with an agreement,
a written agreement.
Yeah.
But if the other person is not cooperating, does not want a divorce, does not want to help, wants to run all those things, so you have to be apart from them for 12 months, and then you can go ahead unilaterally.
Yes. Yeah. And you can move forward unilaterally. Mutual consent is where you have an agreement that's signed. And you can even suppose you do the 12-month separation because the one spouse will not participate in negotiating in an agreement, and you unilaterally file. Maybe they'll change their mind and come to some kind of agreement. So along the litigation process, the court actually encourages and actually does schedule settlement conferences where the parties can talk about resolving all of the things that the court wants to look at. But that's the difference between the two. It's primarily there's an agreement and both people want to move forward with the divorce. The 12-month separation, both people might want to get divorced, but at least one of the spouses is not willing to sign an agreement. Okay. So like leaving the home would be considered abandonment if they lose right. Correct. So the issue is, if I move out, what happens to the house? So this gets into the concept of where people often get confused, and it's a legal thing. So there's what's known as marital property. And that is generally anything that's acquired during the marriage. Okay. So if you get married and you get a house, usually both people's names are on the house. That is different. That's marital property because it's acquired during the marriage. But even if, let's say, the husband just put the house in his name, it's still marital property because it's acquired during the marriage. That's marital property is different than how things are titled. So if I'm on the deed to a house and I'm the only one, then I'm the owner of that house, but it could still be marital property because I purchased the house during my marriage. And so moving out, there's what's called use and possession. And so people say, if I move out, what happens? Well, if that's your residence, and particularly if you're on the deed, you bought the house together, then each of you has a right to enter upon the premises at any time you want, and to restrict people from coming onto the premises, anyone. Now, there's often fights about that. And so, maybe say the wife left and the husband stayed behind the home. And then when the wife comes, the locks are changed and stuff like that. Judges don't like locks being changed and things. Why? It's because the wife has equal rights to the home and to access the home, to access the things in the home, to maybe invite a friend over, or to restrict someone from coming onto the property. So it's a conflict, and it's one of those things where legally it sounds nice, where you both have equal rights to it, but practicality, in a practical sense, there's a lot of friction created there. So if you move out, you just need to be prepared that you might not be able to get back in. Some people need to call the police, and just say, listen, I'm not being allowed into my house. I at least need to go in to get X, Y, and Z. Once you start the divorce process, there is a hearing kind of near the front of the total process, and then you can file for what's called use and possession of the marital home and the things in the marital home, and the judge will decide who gets to live in the house until the divorce is finalized. So hopefully that makes sense. It's not considered abandonment or bad necessarily that you leave. I mean, legally you can leave, and legally you can stay. If you bought the house together and both of your names are on it, you have equal rights to be in the home at any time of the day or night, have people over, and to restrict people. But there's a conflict there. Suppose your husband has a drinking buddy that you don't like, and he comes to the house, and you come to the house, and you don't want him there, but the husband does. It's just a conflict. Again, be reasonable. Don't create conflicts where the police are going to be called. And just sometimes you just have to, as much as I hate to say, you just have to maintain the peace as best you can, and cope the best way that you can, and be reasonable in your own actions. People try to provoke you. Your spouse might want to provoke you by doing certain things. Again, try to be reasonable. But the house thing comes up a lot. But technically, if you own the home, you can come smash the windows and climb through the windows. It's your house. You break your windows in your own house anytime you want, if you want. But don't change the locks. Judges don't like that. Some people will put up video cameras just to record if one of the spouse leaves and comes back, and it creates a lot of tension and there's arguments and stuff. I mean, sometimes video systems are helpful to capture that kind of evidence as well, that you can install in the home. But again, if you're reasonable, the video is going to show that you're reasonable, that you're just coming to get your things or whatever. And as far as if someone says, this is my house, I own it, you need to get out. That's not true if it's purchased during the marriage. It's marital property. So a judge can actually award you use and possession, even though the house is owned by someone else. Say your husband bought it during the marriage. The judge can kick the husband out even though he owns it. And grant you use and possession until the divorce is finalized. So hopefully that answers your question about the house thing. Okay.
So to clarify, if the house was bought during the marriage, regardless of whose name is on the deed, anyone can enter and exit?
That would depend on title, who it's titled to. What you would do is, if it's titled in one person's name, you don't. The best thing to do, it's your residence. So generally, like, the police and the courts will say that's where you live. You have a general right to enter as long as you're not causing disruption. And if you call the police to come and just say, hey, can you at least escort me or allow me in the home? That's generally true. But legally, if it's titled and whoever's titled to, that's who has the ability to enter on the premises and restrict people, even if it's marital property. Does that answer your question? I know it sounds
Yeah,
confusing.
I'm not looking at title in a deed.
Yeah, it'd be the title on the deed would indicate who it's titled to, and then whether it's purchased before the marriage or during the marriage would make it property.
So it sounds like what you're saying, Corey, is that in terms of assets, and there's a question about assets here.
Yes, yeah.
Even if you're not on the title or deed, if it was bought during the course of the marriage, you're entitled to 50% of the equity or worth of the house.
Equitable distribution.
But if you're not on the title or deed, you can't you can come and go as you need to because it's your residence, but you're not necessarily guaranteed you could live there.
Oh.
Is that what you're saying?
If you're on the title. So I mean,
but if you're not on the title, if the house was bought during the marriage, but
you're not, but you're not, then
so
you technically would not have a right to enter any time that you want.
Oh, okay.
Except, so that's technically true. But then there's also, hey, this is where I live, this is where I have my stuff. So generally what the police would say is you need to get your stuff and go. So we'll stay here, get your stuff and go. And then you can go to the court for use and possession to get an order. And that's regardless of who purchased the house or whose name is on it. That could be purchased by one person or both people. That's use and possession. So you go back through the court system to say, hey, I should be the one who gets to live there during the divorce process.
Gotcha, that makes sense. Okay. And then regardless, if it was bought during the marriage,
it's marital property, so it'll be addressed regardless of how it's titled. If it's acquired during the marriage, it'll be addressed by the court. Courts can force the sale of the home, and then the proceeds would be subject, if there are any proceeds and profits, they would be subject to equitable distribution. So, and that's largely what the court, and to tie in with the finances, the accounts, the marital property, it's the same thing with finances and accounts. And so people say, well, this is my paycheck. I went, no, like if I go to work and I bring home a paycheck during the marriage, it's my money, my paycheck, but it's marital property. And if you create bank accounts during the marriage, that's marital property, regardless of if it's in your name or his name or whoever's name. If it's created during the marriage, then it is marital property, and it will be subject to valuation, how much is in there at the time of divorce, and then the judge can equitably distribute the proceeds or the closing of the accounts and those kinds of things. So marital property does include finances and accounts. People say it's, this is my bank account, I created it. That's technically true. But if you created it during the marriage, then it's marital property. And if you put money into it, you earn money during the marriage, that's marital property, even if you earn it. So for example, say you have a husband who works, and then you have a stay-at-home mother. And so the husband will say, I'm the one making the paycheck. No, the money is marital property. It belongs to both of you equally. And even if he goes and puts it into his own account with his own name, it's marital property, and the court will distribute that. We'll put a value on that at the time of divorce, and it's subject to equitable distribution. You may not be able to access the money. Like the bank's not going to listen to you. So, the bank's not going to listen to you because it's his account. So they're not going to allow you to take out money. But just understand that's when you revert back to the court system and you ask, you can ask for alimony, temporary alimony during the divorce as well. And then equitable distribution at the time of divorce. And you say, listen, he has 20,000 in the account. I want 10 of that or whatever. Yeah, so women having a husband bleeding their accounts dry and leaving them with nothing. Yeah, that happens. It happens on both sides, but yeah, people drain the bank account. To be honest, there's not a lot of recourse immediately for that, unfortunately. The divorce is litigation, and litigation takes a long time. Lawsuits take a long time. There is what's called a pendente lite hearing, which is um, um, there is a pendente lite hearing that occurs earlier in the divorce process, and that can address things such as alimony. It doesn't necessarily give you the money back, but if he took the money out, then that needs to be reported to the court, and you can make that known to the court. Hey, he took 20,000, and now he's made it worse for himself, because now he has $20,000 that increases his ability to pay you temporary alimony. So he just hurt his own case by taking all the money. I mean, it makes no sense. But people will do it to spite and to make your life miserable. But ultimately, what they do is they increase their assets, which makes them richer. And the richer you are, the more alimony you're subject to pay. So you hurt yourself by doing that. Yeah, so difference between or alimony and child support. So alimony is based on what the court tries to do. I'm sorry. What the court tries to do is have the lifestyle be commensurate between the parties. So the idea of alimony is that each party gets the opportunity to live the kind of lifestyle that they each had during the marriage. Now, whenever you separate and get divorced, you don't have two incomes anymore, so your life isn't going to be the same. But that's the point of alimony, is that the income and the assets aren't aggregated just on one side, that they're split to allow both of the parties to live lifestyles that are similar. There's rehabilitative alimony. So alimony, there's indefinite alimony and rehabilitative alimony, or what's called alimony for a term. Alimony usually does not last forever. Indefinite alimony is usually awarded only if, say, your spouse is like quadriplegic or something and needs care for the rest of their life. Has some disability. Maybe you'll get indefinite alimony, but it's very rare. Usually alimony is awarded for a period of 1, 2, 3, 4, 5 years. And then the idea is that by that time, both of the spouses should be at a point where they can take care of themselves and make their own lives, and have income to make their own lives commensurate with what it was during the marriage. Okay.
My question with that, Corey, is, does the court ever allow for, so let's say one of the partners has taken time out of their career to raise the children, and for 1 year out of the workforce, your lifetime earnings goes down by about 20%. At least for women, I don't know for men. And so let's say you've taken like 10 years out of the workforce. And you go back in, and I understand, like, in terms of the retirement funds, you're splitting it 50-50 at the time of the divorce. But if you're like entry level, and your partner who's been working has, like, say, well, they have, maybe they have 20 years in their career, you had 10 years, stop for 10 years, and now, like, you're going to a different career, so you're at the bottom. Like, I guess my question is, are there ever allowances in terms of how they divide things to, like, make up for that wealth gap that comes from mainly women? I don't want to discriminate, but mainly women who have been out of the workforce and could never catch up.
Yes. And that's part of what the court looks at in alimony. So, I'll tell, say, my male clients, I say, sometimes I say, listen, if you want to have your wife stay home and raise the kids, hey, that's your life decision. Just realize that what you're doing is you create a liability. You create that liability for yourself, because you advance in your career, you earn more, you become richer in a sense, and then it leaves you exposed to paying alimony down the road to level that out. So the court will consider that in its alimony determination. Okay. And I'm not saying anything good about one parent raising the kids. It's just, if you're trying to avoid alimony, make sure both spouses work, like insist, like we're both working, our kids are going to daycare. That'll reduce your alimony exposure. If you have one person that stays home, one person that works, the alimony exposure goes up pretty dramatically, and it's to account precisely for that. So, and every family will make their own decisions on what's best for them, but the court will take that into account. But the court will also expect that that say if it's the wife who stayed home, that you will use the term of alimony for the duration to get educated, maybe go to college, get a degree, get trained, get certified, get back into the workforce, get back on your feet, because it's considered rehabilitative. There's indefinite alimony is really reserved for very rare instances. The court expects you to kind of get back up on your feet as best you can. Accounting for income loss is something that can be argued in court, and the court can take that into consideration when determining the amount of payments and how long the payments should last. Does that make sense, Sharon?
Yes, thank you.
Any more questions? Okay. And then, like I said, alimony can be addressed during the pendente lite hearing, which is the hearing up front. So it's kind of this hearing up front to address, like, who gets to use the house and stay there, alimony, child support, and custody. Like the core things that people often have disagreements about, that would be addressed in the pendente lite hearing, which is kind of like a mini trial to just to address those matters. And then the litigation process plays out, and then there's a hearing trial at the end if it gets there, but there's settlement conferences along the way. And again, you can always settle things yourself. Many of my clients reach settlement agreements. Maybe it takes 8 months for things to cool down and for people to become reasonable again to the point where they can negotiate something. But you can always negotiate settlements during the entire process. So just because you file doesn't mean that you're committed to going all the way to that trial at the end. And usually you don't want to. You want to have some say and try to settle your case. Right. Any other questions that people have about anything so far? So with respect to custody, if you have minor children, hold on one second, but mediation versus courts. Yeah. So yeah, I'll address that. So the question was about doing mediation versus the courts. So mediation will allow you to sit down and negotiate that marital settlement agreement with a mediator. So usually there's a single mediator, and then the spouses both hire that person and meet with the person. That person will walk them through the marital settlement agreement. So there are attorneys who do that. I think they're called collaborative lawyers, like collaborative divorce lawyers, and they help you create that agreement so then you can file for divorce by mutual consent and do it quickly. So it doesn't get around the need. You always have to file a lawsuit to get divorced. And hopefully that'll change at some point because it's really not necessary, but you still have to file a lawsuit. But a mediator can help you reach that agreement, and then you can file by mutual consent and get the divorce over with maybe in 4 to 7 months, somewhere in that range. It still takes a while to get divorced. It's not fast. So that's the difference between the mediation and the court. So you still have to file in the courts, but the mediator helps you reach the agreement. And then to kind of go back to the grounds for divorce, there's a couple that I didn't mention. So there's desertion, which is one of the spouse just up and leaving just because they can't take it anymore, and they don't intend to come back. and it gets kind of blurry with the 12 months, but it's different. That this is a fault-based grounds where maybe your health and your safety and your welfare are in danger and you need to leave. You can file for desertion. The other spouse can file for desertion. And then there's called constructive desertion, which is sort of the other way around, which is the spouse who just can't tolerate anything leaving, and then they have grounds under constructive desertion. And then there's obviously adultery, and so that's often a big issue. Adultery is obviously any kind of sexual relation with anyone other than your spouse during the marriage. The issue with that is you need proof of that, and it's like, well, how do I get proof of that? So it's based on disposition and opportunity. So that's often getting evidence of, maybe the husband doesn't come home until 7 every night, but he gets off work at 5. It's like, where is he? And maybe you hire a private detective, and it's kind of like the Cheaters, show. If you've ever seen Cheaters, like, they'll videotape the guy parking at another woman's house or something, all the time, or overnight or something like that. That would be sufficient generally to show like disposition and opportunity, where the people are spending time together. The person goes to the other person's residence. It's kind of assumed that what goes on inside is romantic and is adulterous. It's not like flirting or talking with someone on the phone. It's not sexting or anything like that. That's not adultery. And it just doesn't meet the legal grounds for that. Right. The other ground is cruelty, and also what's called excessively vicious conduct. And that is where it's not profanity, it's not arguing, it's not belittling. That kind of stuff is not grounds for divorce per se. It's not cruel, and it's not vicious conduct under the law. This is more where you're being maybe hit, or broken bones, bruises, having to go be seen and be treated by a physician or a nurse practitioner, or go to a hospital or urgent care center, those kinds of things. So there's also sexual abuse as well. That they would fall under cruelty and excessively vicious conduct. It's not just the arguing and name calling kind of things. So there are other grounds for divorce. If your spouse is in prison for a long time and not getting out, and then also if they're in a mental hospital and committed for years, those are also grounds. Okay. So with respect to children, minor children, custody-wise, there's often, it's difficult up front, like if someone leaves with the kids, and then it's like what to do, and sometimes you don't trust your spouse, so you don't want to give custody over to the other spouse, and those are things that just need to be, as best you can, worked out until the pendente lite hearing. Courts will not hear those issues on an emergency basis unless, I had one case where I believe it was the mother took the children, or 3 children, and it was like a drug house with felons and active intravenous drug use. That would qualify for an emergency child custody case. And so you can file a lawsuit actually for child custody. Just by itself. Even if you're married, you can still sue your spouse for custody. But custody would be addressed otherwise at the pendente lite hearing. And otherwise, you just have to do your best that you can to try to negotiate some kind of agreement, and however that works. And everybody's situation is very, very different. So, some have a real risk that if they give the kids over, that parent will go out of state with the kids and won't come back. And other times people get along, and one parent will keep them during the week, and then on the weekends they go with the other parent. Like you can negotiate without an agreement, but you can try to negotiate what to do with the children. And again, a lawyer can help you do that. And if the other person has a lawyer, that might be helpful too, where the two lawyers can work something out because they're not emotionally involved in the case. As far as child support goes, support is kind of complicated, but in general, it can be addressed at dependental ID. It can be addressed in a marital settlement agreement if you agree to it before you file for divorce. But there is like a spreadsheet that calculates or guidelines for child support, and there's a lot of factors into what expenses. And then it's generally based on the incomes, the proportional incomes of the parents. And then it's factored into who has physical custody of the children the most, and that also factors in. So it's kind of complicated. It's more than what we can talk about here, but there are child support guidelines, and there's a sheet that needs to be filled out, a court form that will help the judge determine the child support that is owed. And generally, it will be whoever has the children the most nights during the year, or you can think of it kind of during a week. So if one has the children 4 nights a week and the other has 3, the person with the 3 would be paying over money to the parent that has 4. And so that's generally the way that works.
Can I ask a question? Sorry. So I often get with my clients, they have this absolute fear that their spouse will somehow get full custody, not like disappear with the kids or do anything like really unlawful like that. And a lot of times it's unfounded. Like, I mean, I never talk to their spouses, but it ends up being 50-50 and very fair. But that's like this core innate fear. How often, like, what has to happen for somebody to truly lose custody or lose a custody battle? How often does that happen?
I mean, it's rare. It's very, very, very rare for a court to award one parent sole physical and legal custody of a child or children. It's very rare. I can certainly understand the fear of that because of the meaning and the bond that you have with the children, but it's extremely rare. Courts have a tendency and kind of this general rule that the children need to spend time with both parents and spend both equally, with both parents. That is what is in the best interest generally of the children. So what would have to happen to lose custody? I mean, it would have to be something where maybe one parent is abusive to the children, dangerous, threatens their lives, is like declared mentally incompetent, maybe is on drugs and is a drug addict, and just can't take care of children. Those are the situations in which the children would be taken and given over to the other parent. In a normal case where it's just husband and wife, they hate each other and they just want to get divorced, it's usually down the middle as far as custody goes. Courts prefer that both parents have custody. So trying to make it seem that way. Abusers try, just so I'm clear, abusers try to make it seem what way?
About how somebody's mentally incompetent or on drugs. When somebody wants to really stick it to their wife, usually they'll get out there and make all kinds of claims and argue their point. And I'm just wondering, you're saying that that's not, it's rare, but it is a fear of a lot of people who are, in a marriage with a very difficult person. So you're saying that does not happen often, they succeed at that?
No, I mean the general default of the court is for both parents to share. So you have joint physical and legal custody. So physical custody is the kids being with you and spending overnights with you. Legal custody is the ability to make decisions for children. Courts will the midline is both parents sharing and having joint custody, and that's rare to get away from. There might be one parent who it just works out where maybe the wife wants the kids like during the week for school, and then on the weekends the dad will have them or something like that. And I mean, the courts are flexible. If that's what the parents want to do, and it isn't harmful to the children, then the courts are generally okay with that. But they don't. Judges don't like to tear kids away from a parent unless it's absolutely necessary, mainly for their safety. Um, um, Yeah, and it does take a lot of evidence. Yeah, and you have to have evidence, because if you're going in to claim it, where people tend to use and sometimes abuse the system is with protective orders, or with protective orders. And so they'll go in, and it's really easy to get a protective order, temporary protective order against another spouse, even though on allegations, and the proof required is pretty minimal, and then they'll get custody and things like that. But ultimately, the divorce court, will have ultimate jurisdiction over the custody too. So if you happen to misuse the protective order system, again, that can hurt your case down the road as well. So you do have to have evidence that the parent is harmful to the children. There has to be some concrete thing. Maybe a cigarette burns on the kids, or broken bones. They're going to the hospital, so you have medical records of broken bones, or if they're IV drug user, you have video of them using and falling asleep or something. I mean, it has to be pretty concrete evidence of that, of what's going on. Maybe text messages of you confirming something. But there has to be proof of that. You can't just go in and claim it. Judges hear claims all the time. They know that people hate each other. Sometimes just hate each other, and will say all kinds of stuff about the other person. And they hear that all the time. It's not that they're numb to it. It's just, it's a court case, and it requires evidence. And if you're making that claim, then you have the burden of proving what you're claiming. Generally, yeah, 50-50 is the general assumption. Yeah. Yeah, I mean, if there's any abuse, so the question is, if the spouse abuses the other, can that affect custody? Yes, because there's an assumption that if one spouse is abusive, is say physically abusive toward the other spouse, and commits acts of physical violence, the court will have concerns about the safety of the children. I could see a judge saying, that person has a disposition toward violence, and so it's best to not have the children around. And then maybe if the person goes to anger management classes or whatever, sometimes the court will order like supervised visits, so they won't allow that abusive parent to have custody, but they'll have the supervised visits at the county centers, where the parent can come and at least interact with the child, and then you have government agency workers overseeing that and reporting back to the court, just to make sure that the kids are safe. And then over time, again, even if it's an abusive parent, like say an act of abuse occurred, the other parent can kind of work their way back into good graces. Maybe they go to anger management, they go to supervised visitation and do well with that for a year or so. Then maybe the judge will allow like an overnight or two or something like that with the child to kind of test it out, if the judge feels that that's safe and in the best interest of the child. So again, the idea is for the children to be exposed to both the parents, generally, as long as it's safe. Anyone else? I mean, there was a ton of other stuff, but I mean, anyone have any other like questions or anything that they've heard? No, so there is. So the question is there, do courts favor women or men? No, there was back in the day a presumption, like for custody, there was a maternal presumption, where the father had a more difficult time, but that's since been done away with, and so there's sort of equality, if you will, in consideration of it. So again, courts tend to favor and view that it's best to have the children be with both parents and exposed to both parents, and there is no presumption that the mother should get custody, say, or the father should get custody. It's really just looking at it. It's a vague standard. It's a vague standard. It's just called the best interest of the child. It's a very ambiguous legal standard, but that's what the courts consider. What's in the best interest of the child or the children? And I mean, the good thing is you can bring in a lot of evidence. So it's a pretty open standard. So I'm trying to think if any. Let's see if there's any like major. So the idea, I guess I'll just kind of conclude. The idea is of the court in a divorce case is to deal with all the children aside, is to take a look at all the marital property, put a value on it, and decide how it gets distributed. So that's everything from savings accounts, checkings accounts, cars, and what their value is, personal property, maybe diamond rings or houses, vacation homes, retirement accounts, pensions. All of that gets, as long as it's marital property, as long as it's acquired during the marriage, there are some exceptions to that, but acquired during the marriage, the court's primary role is to put a value on all of that, and then to do equitable distribution of the proceeds. And that's generally, think of it as 50-50, but equitable distribution doesn't mean 50-50. You don't always get 50-50, and you're not always entitled to 50-50. You're entitled to equitable distribution, which is kind of like whatever the court thinks is fair. And again, it's an ambiguous standard, but that's what the court does. So if say the husband's accumulated a retirement account, it's up $300,000. That the court would look at that and do equitable distribution. So maybe the wife gets 50% of that. So there would be the retirement plan would actually have to separate out that money and transfer it over into an account created by the wife, for example. So and then the court could order, there's special orders that the court puts in to tell the retirement plan to do that. If it's cash and bank accounts, then the court can order one party to pay the other. So the husband takes the $20,000, the court could order him to pay 10, 12, 15. Maybe if the court thinks he was a jerk for taking out the money, and so they say, I want you to hand over 18 or 18,000 of the 20, and he'd be responsible for paying under a court order. Inheritances are excluded from marital property. So that's one of the exceptions. Inheritances, property acquired prior to the marriage. So if I don't know, say I had like a painting, like a really valuable painting that I had before I got married, and then I got married, and it's worth $1 million. That $1 million is not marital property. That said, that $1 million makes me a rich guy that can pay alimony. So the court can factor it in, but the court's not going to do anything with the painting itself because it's not marital property. So it doesn't get divided out, but it does get included in my assets, which again makes me more wealthy, and then makes me more liable to pay things like alimony. It affects equitable distribution because maybe I don't need money on my half because I have the $1 million painting. So it can affect equitable distribution over onto the other side. So any other last minute questions? I think kind of covered everything. We were left totally destitute. People being left destitute in divorce, it's not equitable. I don't know. I usually see things go awry when people don't have attorneys and the other party does. And the difficulty is sometimes, like the stay-at-home mother, if the working dad leaves and then sucks the bank accounts dry, how's she going to pay for a lawyer? And so you see that sometimes. I mean, there are pro bono services and lawyers who do pro bono, but I usually see things go awry when people don't have attorneys do that. If there are attorneys, it's really rare. I personally have never seen a case where someone just got everything and left the other person destitute when there's attorneys involved. I've never seen that happen.
The bottom line is, if you have to beg, borrow, or steal, get yourself a good attorney.
Yeah, and I am an attorney, but it's it's helpful to have. It's so emotionally tumultuous, the process, and it helps to have someone there to support you. And I tell my clients, I say, do the best you can to take care of yourself. Your mental health, your physical health, and it affects your eating and your sleeping and your anxiety and your thought processes. And it just helps. Having an attorney helps because it's an objective person who can kind of step back and give you advice in times that are tough, and it's hard, and sometimes it's hard to be reasonable, and it's hard to, if someone does something to you, you want to do something back, and that isn't always a good idea. So a lot of it is like talking clients out of stuff. I had a client recently that wanted to, paying. They weren't divorced. He was paying her, not kind of like an alimony, like a monthly stipend, so she could have a decent living. And then, she filed for divorce, and all of a sudden he wants to stop. And it's like, no, don't do that. The judge will think, no, judges will not like that. Just keep the status quo, keep cool, just continue the status quo, and that way she can continue to live, and you can continue to live equally. And so, in any event. So I thank you all for attending. I wish the best for all of you. And Sharon, if you ever need any other presentations or anything, just let me know. I'll be happy to do them. Okay.
Thank you so much. This has just been absolutely valuable. I think we all learned a lot, and I really appreciate you taking the time to share your expertise. It's really very eye-opening.
Yeah, sure. Well, thanks for having me. Everyone have a good day. Okay.
Thanks. Take care. Bye.